People's emergency motion. Go ahead. You may proceed.
Thank you, Your Honor. The people filed this motion, I believe.
This case wastes absolutely no time raising the stakes. What starts as an emergency bond motion quickly turns into a courtroom debate about one of the most important questions any judge faces. Can the community, and more specifically the alleged victim, be kept safe while the defendant remains out of custody? The prosecution is already signaling that they believe the original bond conditions were not strong enough, and that immediately grabs everyone's attention. Bond hearings aren't about determining guilt or innocence, but they are about risk. And when prosecutors begin laying out allegations involving threats, weapons, and repeated intimidation, the entire tone of the hearing changes. Judge Simpson now finds himself balancing two competing concerns: protecting the public while also respecting the defendant's rights before trial. As we move through this hearing, pay close attention to how each side frames the same facts differently. One side sees danger, the other sees allegations that have not yet been proven. That tension is going to drive everything that happens next.
The defendant was arraigned on May 1st and was given a personal cognizance bond, and this was against people's request for a $25,000 cash surety with a GPS tether. People have serious concerns in this case for particularly the victim's safety, with nothing more than a PR bond in place. In this case, the victim's defendant had an argument. He called her a fat bitch and pulled out a knife. He was held the knife to her throat while yelling in her face, "If you interrupt me again, I'll snuff you and kill you right here." He was so close to her face while he was yelling this that spit was hitting her face. He said right before he left the car, he stated once to her that once he gets his disability check, he's going to buy a .22 caliber gun and shoot her in the head. She's in fear for her life and her mother's. And she also received a text, which I believe, and for it to be read into its entirety, and it says, "You better for real stay out of my way. Don't text me unless I text you. You take my child's phone away again, I'll dismember your whole body to pieces. No cap. I'm overplaying with you. I will literally just kill you and get my life right. Free healthcare. My daughter's safe with your mom. Keep fucking playing. CUNT. I promise you don't know how real I am." And I have just extreme concerns given that he held a knife to her throat and is threatening on multiple occasions in this one case to kill her. And after the arraignment, the victim did send us a screenshot of a text, I believe from March 28th, which was before this case occurred, from the defendant, in which the message said, "Call the cops, I don't give a fuck, I'll murder your ass the day I get out." And that was before this case. So I have concerns given that she has finally reached out to police about this defendant's behavior, what could happen to her, given that he's out on a PR bond for this, in which he threatened her life twice. Oh, probably more than twice, I believe. 3 times.
Response.
That single word from Judge Simpson shifts the momentum of the hearing. Up to this point, the prosecution has delivered an alarming series of allegations and threats that paint a deeply troubling picture. Now the defense gets its opportunity to answer. Notice something important here. The defense does not try to relitigate every accusation. Instead, they focus on compliance. That's a common strategy during bond arguments. Rather than debating the entire case, they highlight facts showing the defendant is following court orders. The GPS tether was obtained quickly. Social workers are involved. Housing assistance is being pursued. Medical appointments are scheduled. These details are designed to show structure and accountability. The defense is essentially telling the judge, whatever the allegations may be, look at what my client is doing right now. It's a sharp contrast to the prosecution's argument focused on danger. The courtroom is now looking at 2 competing narratives, and Judge Simpson has to determine which factors deserve the most weight when deciding whether bond conditions should change.
Your Honor, I'll be requesting that the court maintain the PR bond with GPS tether. Mr. Clark is currently on a GPS tether. It was addressed that day that one issue, as noted in the prosecution's bond motion, was a concern about a cell phone. Mr. Clark does have a cell phone, which he is using now for his GPS tether that's currently on his ankle. The concern was a lack of data, not him not having that device. He now has data on that cell phone. He received that. He had until Monday today, the 5th, to obtain that tether device. However, he did so within 24 hours. He was released from jail on May 1st, 2025 at 3:57 p.m. I received a call from Mr. Washington, one of the tether agents from Community Corrections at 1:22. So within that small time frame, he was able to obtain data for his cell phone and go to Community Corrections to get a tether. Mr. Clark has also been in contact with social workers, one of whom who drove him here today, who are assisting him greatly in obtaining housing, which he is now on a list for those who are chronically unhoused, and hopefully should be able to obtain housing soon, and to be put on a second list as housing vouchers are now being opened again. They've also been assisting him with other matters, such as his health. He is currently suffering from liver failure and has an appointment scheduled for May 9th and one for June 14th, which at that time, his social worker will be also assisting him in getting a hotel. As noted in the emergency bond order by the prosecution, Mr. Clark has successfully been dismissed from probation in the past, showing that he can follow court orders. He does have the money to pay for the tether. He does have transport for the court. And the complaining witness, while acknowledging that this is a serious case, does reside over 30 minutes away by driving. Mr. Clark does currently rely on his social worker for transportation. Again, those, as mentioned, anything mentioned by the prosecution, it's still allegations at this point. We are not here to litigate any of the allegations here today. We are here to address bond. I do not believe there is any change in circumstances that have occurred since his arraignment that I handled last week that would warrant any changing of his bond.
This may be one of the most important arguments presented by the defense during the entire hearing. The phrase change in circumstances is doing a lot of work here. Why? Because courts often need a compelling reason to revisit decisions that were made only days earlier. The defense is essentially arguing that the judge already evaluated the situation, already imposed conditions, and that nothing new has happened to justify tightening those restrictions. At the same time, the prosecution is emphasizing the seriousness of the alleged threats and the victim's fear. That's what makes this hearing so interesting. It's not simply a disagreement over facts, it's a disagreement over risk assessment. Should the court react more aggressively because of the severity of the allegations, or should it maintain confidence in the existing GPS monitoring? Here's a question for viewers. If a defendant immediately complies with every bond condition, but the allegations involve repeated death threats, which factor should carry more weight in a judge's decision? That's exactly the dilemma facing this courtroom.
He is currently on a GPS tether. The court can know where he is at all times. And I believe that this bond is sufficient to protect community safety and fight.
Is the GPS just location tracking?
It's location tracking and includes an exclusion zone for the complaining witness's address. So he would not be able to get within a quarter mile of that address.
Where's the defendant residing at this point?
He is currently residing at a camp as he awaits housing.
At a camp?
Yes, he has a campsite that he resides at.
Where's the campsite?
It's by the Miller and Maple Park and Ride, sir.
Well, just so that we're clear, this isn't by the Maple Miller Park and Ride?
Yes, sir.
So this isn't a commercial campsite. This is just a place that you have.
But I'm holding out until I can get help, sir.
Yes, so she is part of the Pathway Housing Program. I do have a letter from that social worker here if you'd like that, Your Honor. And Ms. Montaigne, the coordinator for that program, is in the courtroom at this time.
Pardon?
Ms. Montaigne, the coordinator for that program, is also in the courtroom. She is the one who helped Mr. Clark arrive at the court today.
The only address I have is the South Line address? Is that a correct
I
statement?
believe so, Your Honor.
Listen carefully to the direction of Judge Simpson's questions here. He isn't just gathering random background information. He's mapping relationships, living arrangements, and proximity. Judges frequently do this when evaluating potential safety concerns. The court wants to know how the defendant knows the alleged victim, where the child lives, whether family members share residences, and how easily contact could occur. Every answer helps build a practical picture of real-world risk. What's particularly notable is that the discussion keeps circling back to overlapping family connections. A shared child, prior history, and close personal ties can complicate enforcement of no-contact conditions. These aren't strangers who can simply avoid one another forever. The judge appears focused on understanding how daily life functions for everyone involved before deciding whether additional restrictions are necessary. That kind of questioning often signals that the court is thinking beyond simple GPS tracking and considering broader protective measures. The deeper this inquiry goes, the more it feels like Judge Simpson is preparing to make a very specific adjustment rather than simply leaving everything unchanged.
How do the defendant and the alleged victim in this case, how do they know each other?
Your Honor, I believe they have been in an on and off relationship since January of 2018, and they have one child together, and that his previous DV from 2021 was with this same victim.
The child resides with mom. Is that
With her mother,
Her mother.
the victim's mother.
Which the magistrate did order no contact with the victim's mother as well on the day of the event.
I see that, but so does the victim reside with the mother also?
I believe so, because it says the child attends school in South Line as well, so I believe so.
How old's the child?
They were born in 2019.
Oh, 6. 6. The defendant's not working.
The defendant is working on getting a disability at this time due to some of his medical concerns.
Yeah, then how is he paying for the tether?
He does have some, he has shared with me, he does have some money for the tether.
Panhandle and pick up cans and do work for a lady that I know whenever she needs it. She hires me for yard work.
So how long have you been residing at the campsite that you set up?
Since last year, sir.
At this stage, the hearing becomes surprisingly personal. Instead of focusing solely on allegations, Judge Simpson is examining the defendant's actual living situation and financial circumstances. Those details matter more than many viewers realize. Bond conditions only work if they are realistically enforceable. The court wants to know where the defendant lives, how he pays for monitoring, how stable his environment is, and whether he can continue complying with court orders. The answers reveal a difficult situation involving homelessness, temporary shelter arrangements, and limited income sources. Yet from a bond perspective, the judge is also looking for something else: reliability. Can this person consistently follow restrictions? Can authorities locate him? Can monitoring systems function effectively? Those questions directly impact public safety concerns. Another interesting point is that Judge Simpson is gathering this information himself rather than relying entirely on attorneys. That often indicates a judge who wants a complete factual foundation before making a ruling. The hearing is clearly approaching a decision point, and every answer is helping shape what that final ruling will look like.
Are you the only one out there at that site?
Yes, sir.
Let me see, counsel in chambers, court standing. I've had an opportunity to speak with counsel in chambers, and what the court is going to do at this time, and Mr. Clark, I need you to understand what I'm going to do. I'm going to leave you on the GPS tether. I'm not going to increase any monetary bond that might incarcerate you. Okay, you understand that, sir?
Sure.
And then what I'm going to do is I'm going to, at this moment, increase the exclusion zone on your tether for all of South Lyon. Okay.
I understand.
And then, and I don't want it put on the record, but I'm also going to add a provision of no contact with the minor child. You understand that, sir?
Yes, sir.
All right. And then once the other part to this is that may change where I get more information regarding the victim, the alleged victim, and her travels. And then I may be expanding that exclusion zone. Follow me?
Yes, sir.
All right. So that's what I'll do at this time. I think I'm going to need a new order. So I'll prepare a community corrections order with the exclusion zone as all of South Lyon. And then Ms. Zenda, if you could provide to the clerks the name, the minor child's name, and then we will be adding that to the no contact. So at this time, I guess theoretically the motion is granted. The exclusion zone will be extended to all of South Lyon, and I will add the child's name there. Anything further?
Nothing for the people, Your Honor.
Nothing from the defense, Your Honor.
All right. Thank you. Thank you, sir.
And there it is, the ruling. Judge Simpson ultimately lands somewhere between the positions as advocated by both sides. He does not impose a higher monetary bond that could result in incarceration, but he also does not leave conditions exactly as they were. Instead, he expands protections by increasing the exclusion zone and adding a no-contact provision involving the minor child. That's a significant outcome because it shows the court recognized the concerns raised during the hearing while still allowing the defendant to remain on bond. Throughout this case, the central issue was never guilt or innocence. The focus was risk management before trial. The prosecution argued that the alleged threats justified stronger safeguards. The defense argued that the defendant was complying with existing conditions and should not face harsher financial restrictions. Judge Simpson's decision reflects elements of both arguments. The GPS tether remains, incarceration is avoided, but additional boundaries are put into place. In short, the court chose tighter supervision rather than a harsher bond. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.